Honorable, the Chief Justice and the Associate Justice of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable of the Supreme Court of the United States are admonished to draw near and give their attention. The court is now sitting. God save the United States and the court.
We'll hear argument this morning in number 21707, Students for Fair Admissions versus University of North Carolina. Counsel for petitions.
Mr. Chief Justice, and may it please the court. My name is Campbell Collins, and along with my co-counsel Gabriella Levins, I represent the petitioner, Students for Fair Admission.
We ask that this court overrule Grutter v. Bollinger. The University of North Carolina employs an affirmative action program that provides a benefit to certain races to the detriment of other races. This program is unconstitutional under the Equal Protection Clause of the 14th Amendment. This program is unconstitutional for two reasons. First, UNC's policy does not achieve a compelling state interest, and second, their policy is not narrowly tailored.
First, strict scrutiny is the appropriate standard here, and UNC's policy fails strict scrutiny because it does not achieve a compelling state interest.
As the respondents agree on page 13 of their brief, strict scrutiny is the correct standard to look at all affirmative action race-based policies under. The first issue then is whether a compelling state interest is achieved by this policy.
It's not, because even though Grutter held that the educational benefits of diversity are a compelling state interest, that decision was wrong, and it breaks from this court's tradition regarding racial classifications. To be a compelling state interest, a classification must achieve something that is a matter of pressing public necessity. That comes from Korematsu, and even though Korematsu was overruled, the reasoning in that case is what led to the development of the compelling state interest standard that was codified under Bakke. So because racial classifications need to achieve a pressing public necessity, the educational benefits of diversity fail. And in fact, they're much more similar to compelling interest.
Who gets to decide in our country? Who should decide whether this is a compelling interest? Isn't this a decision for the legislature?
Well,
I mean, race has been the issue we've wrestled with for years. Why should unelected judges decide whether it's important for the national policy? Why should the legislature decide? They clearly, they have, and they happen in every state, but in some states they have. Why not let them do it?
Well, Your Honor, because the legislature and any branch of the federal government doesn't have the power to sanction unconstitutional racial classifications, which is what these classifications are.
So there's some racial classifications that are constitutional, these are not.
Well, Your Honor, there's the potential that there might be a racial classification because we know that the court has said that
the Reconstruction Congress used racial classification.
Actually, Your Honor, all of the laws that dealt with race.
No, your Freedmen's Bureau thing, come on. There's nothing about being a justice on the Supreme Court that precludes one from exercising common sense. And the Freedmen's Bureau was giving a benefit to African Americans that had been slaves, but they were African Americans. They weren't any white folks that were getting benefits.
Well, Your Honor, even if that's so, the Freedmen's Bureau Acts dealt with a completely different compelling state interest. They dealt with racial remediation because the government specifically...
And the legislatures have made it, government is, certain states have made a decision that it's a compelling interest to allow people who have been the target of discrimination in the past to have access to upward mobility through education. The government, countries decided this is a really important issue for us.
The important distinction there was that the government had harmed these individuals. In affirmative action, no one has directly harmed students who are getting the benefit.
Then we get the whole issue of systemic racism. I don't know if we need to go there.
Well, no, Your Honor, because the court in Wygant specifically rejected remedying societal discrimination as an interest for affirmative action policies. So the only justification for these policies that has ever been sanctioned by the Supreme Court is the educational benefits of diversity. But that decision in Grutter to sanction that interest was wrong because the educational benefits of diversity don't rise to the level of a compelling state interest. They may be a good policy, they may be a laudable goal, but that doesn't mean that they justify classifying students based on race and harming some and helping others.
Grutter also applied a presumption of good faith to the law school there. Should we be doing the same here?
Well, at the end of the day, strict scrutiny gives no deference to the courts, as was actually held in Fisher 1. Gives no deference to the schools. So no, we shouldn't give a presumption of good faith. We have to really examine their policy.
So you're saying that Grutter actually did apply strict scrutiny or misapplied strict scrutiny?
Grutter did apply strict scrutiny, but it was misapplied because the interest that they justified as compelling just wasn't. In fact, it's much more similar to interests that the court has rejected in the past, such as the best interests of the child in Parlamore v. Sidoti, and having role models in the faculty to alleviate societal discrimination in Wygant. So just because a racial classification would lead to a good end doesn't mean that that classification is justified under the 14th Amendment.
What do you do with Reconstruction era statutes that specifically benefit blacks as opposed to freed slaves, like the ones in the district, setting up the school system, the relief program? The trigger for those was race, not status as a former slave.
Well, the school district in DC was again remedying a specific harm caused by the government because DC had created a school system where black students could not be enrolled. The problem there was Congress seems to have endorsed the segregated schools by never saying, okay, you have to make one school where anyone could go. So that's a little questionable how much weight segregation there is given, but that law was not exactly race-based because it was redressing a specific harm.
North Carolina was the slave state of the Confederacy. Why can't they?
Well, yes, Your Honor.
Why can't they do the same thing for their own university?
They have to be more specific than redressing a specific harm, because Wygant told us that societal discrimination without more is too amorphous a basis for imposing a racially classified remedy.
No, that's true, but you have an identified discriminator.
Well, yes, Your Honor.
Cases like Stott say you don't need an identified victim. If you have an identified discriminator, then racial preferences are justified.
Well, Your Honor, UNC doesn't make that sort of distinction. Instead, what they do is they take information that a student provided by checking a box for their race, and they use that to categorically change the way they treat those students. We know from the record that, for example, an Asian American student in the top decile, the top academic performance decile, has a lower chance of admission than an African American student in the fourth highest decile.
It's a blunt tool to be sure, but don't you think the country is better off today because of the use of affirmative action than it would be otherwise?
Well, no, Your Honor, because as you say, it is a blunt tool, and the universities aren't allowed.
I think your answer to that question would be different if your life experience perhaps were different.
Well, no, Your Honor, because affirmative action doesn't have anything to do with anyone's individual experiences. It treats an Asian American student who has faced severe discrimination exactly the same as an Asian American student who hasn't, and it treats an African American student who has faced severe discrimination exactly the same as an African American student who hasn't. It's not incisive enough to treat students as individuals. Instead, it treats them as groups, and because it treats them as racial groups, it's unconstitutional.
If we're concerned with addressing specific harms that have come to specific groups, we come across a problem with the university's treatment of Asian students. We saw recently a dramatic spike in crime against Asian people with the past years. So then when we look towards Asians are the ones facing the worst harm from affirmative action programs, it's hard to draw a connection between affirmative action to fix bad parts of society and how Asians are being treated. It's more of a pick your favorite minority rather than a real fix.
And furthermore, the educational benefits of diversity are too amorphous a basis for this policy. Because the best that the respondents can do is say maybe there's a daisy chain of logic that connects military sufficiency and racial diversity in schools, but by that logic, any set of inferences could justify a race-based policy.
The second.
Sorry, finish.
I was moving on to narrow tailoring.
Well, let me just ask you before you that to address stare decisis, because you're asking us to overturn 50 years of precedent and a practice that is, for better or worse, ingrained in every university in the United States of America. So,
Well, yes, Your Honor.
why should
Yes,
that dramatic?
yes, Your Honor, we are asking that, and it's justified for a couple of reasons. First, because stare decisis is a general principle, but it's not an inexorable command, and it's at its weakest when the court interprets the Constitution. And second, because the court has continually rejected the idea that just because removing discrimination is hard means that we shouldn't do it. In Brown, it was extremely difficult for the court to say to school districts, you have to integrate, but they did it anyway because it's so important that the federal government doesn't discriminate on the basis of race. And
Don't you think the argument you've given right now is a better argument than in the brief by waving Dobbs at us? Dobbs, you gotta be careful about Dobbs, right? Dobbs is not a license to judicial activism.
Well, that's correct, Your Honor, it is not. But the factors that it laid out do support this idea that because Grutter is just so wrong, it's time to overturn it. Because it doesn't meet the factors in Dobbs for good precedent, and also because it's important that the federal government not discriminate.
Mr. Chief Justice, and may it please the court, I'm Katie Gutowski.
And I'm Quinn Speck, and together we represent the respondents in the case of Students for Fair Admission versus the University of North Carolina. Would the court like a brief statement of the facts?
I think we're familiar with it.
The original meaning of the 14th Amendment does create a broad protection against arbitrary discrimination. However, the University of North Carolina's limited use of race in its admissions process is not arbitrary and is constitutional under the 14th Amendment's Equal Protection Clause by both the original meaning and spirit of the 14th Amendment, as well as the precedents of Bakke in 1978, Grutter in 2003, and Fisher II in 2016. Petitioner's claim should not be affirmed for 4 reasons. First, Petitioner argues incorrectly that student body diversity is not a compelling state interest. This court has consistently held the contrary for half a century, and instead has focused its inquiry into whether or not admissions regimes are narrowly tailored to achieving student body diversity. After an exhaustive review of hundreds of thousands of documents, the district court in this case correctly held that the University of North Carolina's program met this burden, and Petitioner's brief does not contest the facts in this case.
Second, contrary to what Petitioner wrote on page 9 of their brief, neither in Brown v. Board's holding nor in its opinion did this court ever explicitly prohibit, quote, the use of race as in affording educational opportunities. Instead, the holdings in Bakke, Fisher II, and Grutter control all stare decisis considerations in this case.
Third, Petitioner's arguments themselves cannot satisfy the standard of history and tradition they derive from Dobbs. As Justice Alito wrote, citing Gamble v. United States, Petitioner must settle, quote, the historical question with enough force to replace precedent. Unlike in Dobbs or in Bruin, the original public
I want to
understanding...
begin by quoting our illustrious Chief Justice. I won't quote it, paraphrase it. Isn't this a tawdry business as we divvy up the nation by race? Aren't we flying in the face of Dr. King's canonical speech where he said, we're hoping for America, we're judged by the content of our character and not the color of our skin. And yet you're telling us the color of our skin matters, and it matters despite what the Constitution says.
Well, Your Honor, if we actually look to what the 14th Amendment meant in its original meaning, if we look to the text of it, the 14th Amendment says that no state shall deny to any person within its jurisdiction the equal protection of the laws. And so when we're talking about issues of race, we're only acting to...
Hold on. Sorry, are you going to argue the purpose of the 14th Amendment or the text of it? Which horse are you going to ride on?
Well, we believe that first we look to the text, and the text there...
The text says nothing about race.
Well, Your Honor, as we outline on page 12 of our brief, the framers of the 14th Amendment, in writing the 14th Amendment, explicitly rejected numerous proposed drafts of constitutional language that would prohibit race-conscious policies such as those that they enacted.
So the text of the 14th Amendment doesn't use the word race. It talks about equal protection of the law. So how do we get to talk about race? What's the principle underlying the 14th Amendment if it's not just race?
Your Honor, as a broader answer to your original question, we do believe that what our clients at the University of North Carolina are doing in practicing affirmative action is very much in the spirit of Brown, of bringing people together and not separating them arbitrarily based on race.
The 14th Amendment. What's the 14th Amendment?
Well, Your Honor,
What's it require?
we believe that when we're talking about the original meaning of the 14th Amendment, if we actually look to Barnett and Barrick's comprehensive history in 2021,
now we're moving to purpose.
well, if we look to,
Can we just start with the text? The one textual clue that I see in this seems to cut against you is the word person. The anti-discrimination principle is vested in individual people. Every individual student has the right to equal protection, not groups.
well, Your Honor, we believe that the University of North Carolina, one, ensures that each student has equal opportunity to be admitted. It does this by considering over 40 separate factors, and so it truly does employ a holistic process in its review. But more than that, if we are looking at what the 14th Amendment says, it does not prohibit the use of race as long as it's limited. And if we can look to the original public understanding of it, which when it was being used, there are actually no discrimination litigation examples that made any mention of the Equal Protection Clause.
You've got a problem here, right? Because there's no serious doubt that the framers, the ratifiers of the 14th Amendment, were not trying to unravel segregation in public school. So what do you do with the purpose there? We're going to make a purpose argument. How does that help?
Well, Your Honor, if we would be able to respond to what Petitioner said about Dobbs and about the standard of a history and tradition test, such as what was put forth in Dobbs, we believe that the history and tradition of this issue of affirmative action supports our stare decisis argument, and we believe that the case law, the past half century of case law on this subject.
If the 14th Amendment doesn't identify race specifically, what is the principle that's animating?
The principle is equal protection, but it's equal protection as it applies to protection against violence. And I think that's the main thing that we have to consider when we consider the original meaning of the 14th Amendment. Really, it ensures a governmental duty to protect natural rights, not post-political goods, which is what...
and you haven't said anything about race yet, and yet your argument is based on the government can make distinctions based on race. Why? What is there about race that is so noxious to us that we won't allow the government to act based on it?
Well, at the time of the ratification of the 14th Amendment, as you mentioned in questioning the Petitioner Council, there was a lot of racial tension with the Civil War just being ended. And so...
Then why didn't they use race? Why didn't they just say race? They didn't. Be broader than that.
They didn't say race because they ultimately wanted it to include all persons, and the broad language there of all persons was meant to include not just citizens of the United States, but also foreign visitors.
Maybe it's getting at the government acting against people who, based on their immutable characteristics. Right? Race is an immutable characteristic. Government can't act based on something that someone has no control over, right?
Well, Your Honor, I think, again...
Is that a principle involved with equal protection?
I think if we look to when the 14th Amendment was actually used, it was used in the context of the conversation around the Klan Act in 1871. It was used as an instrument to make sure...
That's all race, right? What I'm getting at is we know the purpose is we tried to get at racial discrimination, right? But it used broader language. And what I want to suggest is maybe you're going to go with your purpose argument. Maybe you can't stop at race. Maybe the principle that's animating the Equal Protection Clause is broader than race. Maybe it gets to immutable characteristics and other categories. Would you agree with that or not?
Your Honor, we believe that although the general principle may be broader than race, we still believe that race is a very important distinction in the Equal Protection.
Is it the only one?
It may not be the only one, but we believe that it's the...
So I want to know what's the limit on your argument?
Well, the limit of our argument is in the context of affirmative action, in the context of the precedents that this court has offered on that. When we look to Bakke, which specifically said race can be used, Justice Powell wrote, as one of several factors. And then this is continued through Grutter, where race was upheld as constitutional under strict scrutiny. Again, in Fisher too, where race was upheld as being, or rather, where student body diversity was upheld as being a compelling interest and is narrowly tailored. And affirmative action is narrowly tailored to that interest.
So Grutter suggested that this would be acceptable for about 25 years. Do you agree with that?
Well, Your Honor, we would read that to be aspirational, and if we're pulling the direct quote from Justice O'Connor's Grutter opinion, it's that the court, quote, expects that 25 years from 2003, the use of racial preferences will no longer be necessary to further the interests approved today. That's from page 343 of the Grutter decision.
So was she right about that?
Well, Your Honor, what we believe about the use of affirmative action is that it will eventually see an endpoint, and we can look to the example of states like Georgia.
5 years.
Well, Your Honor, we need to evaluate this on an ongoing basis. But what we want to be clear about here is that student body diversity will always be a compelling interest. The question is whether affirmative action.
And your brief points out, I think, Georgia, Florida, California. I mean, there's a number of very big states that managed to make this transition. Seems like successful. Why can't UNC do that as well?
Well, Your Honor, we have a few answers to this question. First, we'd like to bring up the fact that leadership from the state school systems of both Michigan and California have filed amicus briefs in favor of the respondents. So clearly, they are trying to signal that there have been significant drops in diversity levels on their campuses that have not been desirable to educational quality.
Closer and more like Georgia and Florida.
Well, in the cases of Georgia and Florida, those were decisions that were made either by, I believe in Florida was an executive order from the popularly elected governor, and Georgia was made through the state legislature. So we believe that if the petitioners want to talk about upholding the standard of Dobbs, we believe that we should look to Dobbs for guidance on these constitutional principles of popular sovereignty and federalism, and ultimately leaving this decision up to the states, just as was done in Dobbs with abortion.
But what I'm suggesting to you is if all of these other states have managed to create good educational systems that provide diverse student bodies and done this without discriminatory measures, shouldn't we expect the same from the West as well?
Well, Your Honor, what we can actually look to the modeling studies done at the district court level by the University of North Carolina, where in 2007, 2009, and again in 2012, the university and the admissions office reviewed race-neutral alternatives and how effective they would be.
I saw that, and it looked like they were doing it every couple of years, but they haven't done one in a decade. Why is that? And doesn't that suggest perhaps maybe you all aren't acting in the good faith that Grutter suggests we should assume?
Well, Your Honor, UNC does have an ongoing committee presently that assesses race-neutral alternatives on an ongoing basis. And furthermore, the district court in this case found, I believe the quote was that the University of North Carolina had given serious good faith considerations to race-neutral alternatives.
What do you do? There's some emails and texts in there where people are saying how each of state's admission officers help us understand how that's consistent with your argument you're acting in good faith.
Well, Your Honor, if we look to the findings of fact at the trial court level, 380,000 pages were reviewed and 200,000 applicants were reviewed. And there were only 8 quotations that could be found of these kinds of statements that were made in terms of text messages, emails, and whatnot. However, on page 31 of the trial court's findings, it stated that non-statistical evidence does not demonstrate discrimination, and rather, one, there's no evidence that UNC conceals the improper use of race behind opaque procedures.
And these are findings of fact from the district court, and to our knowledge, Petitioner does not dispute the district court's findings of facts in this case.
And
we talk about history. What's your best example of Reconstruction era laws benefiting blacks as opposed to whites? It seems to me you have 2 categories of laws, basically. The Freedmen statutes, which are key to status as a former slave, and the District of Columbia sort of statutes, which are basically separate but equal, with an emphasis on the equal. I didn't see any statute where Congress undertook to afford preferential treatment to to blacks as blacks based on race.
Well, Your Honor, as your colleague on the bench said when questioning petitioners, the Freedmen's Bureau, although it was technically based on status as a former
slave.
Yeah, it's still ultimately.
Well, Your Honor, we can actually look to other examples where it is race-based legislation, specifically in universities, that is determining it during Reconstruction, that is determining these kinds of race policies. So Berea College, for instance, used quote the total equality, looked for quote the total equality of the Negro in forming its admissions process, not formerly enslaved. Not the issue of formerly enslaved persons. And the University of Michigan is another example where throughout Reconstruction, it employed race-conscious affirmative action, even though...
Wasn't there a law, state law, Kentucky law requiring segregation?
Well, Your Honor...
It's an all-black school because it had state law at the time, no?
Your Honor, I think that even if we look to these examples, when we're looking to race-conscious legislation that was used by the Freedmen's Bureau and other kinds of things to improve the status of minorities, that is different from times when they're segregated, because we believe that there is quite a distinction here where if the Constitution is both, it can be viewed as color conscious in some senses and colorblind in other senses. So the Constitution, to avoid conflict with the Equal Protection Clause, a classification that is denying a benefit or causes harm or imposes a burden can't be based on race, because and so in that sense the Constitution would be colorblind. However,
at the time, I'll let you finish the thought.
Well, however, in the Constitution is color conscious in order to prevent these minorities from being harmed. And so ultimately, because the stare decisis in this case is actually consistent with the history and tradition, it should be upheld.
Thank you, counsel. Your rebuttal.
May it please the court. We would like to address 2 points that the respondents brought up. First, UNC's policy is not narrowly tailored, and second, UNC doesn't even follow Grutter. Now, if UNC was truly concerned with achieving diversity, they would consider lowering their standards. They could fix their diversity problem tomorrow by lowering the standards of admissions, and then we wouldn't even be here. Second, they could deal with legacy.
They have an interest in attracting the strongest possible candidates consistently.
I do think they have an interest in attracting the strongest possible candidates, but I don't think they get to discriminate to do that. And if they want to argue that they're not tailoring or that they are sufficiently tailoring their policy, they're not, because they can achieve the educational benefits of diversity at the cost of their hyper-elite status.
For UNC's policy to outweigh constitutional requirements, it also has to outweigh their other institutional priorities, but we know that it doesn't.
What role, what about your argument? We need to overturn. What role, if any, should we place public reactions? Should that be something we think about at all?
Well, to a certain extent.
Because as you point out, we've got 50 years of precedent here. To reverse that, some people say based on change of personnel. Should that be something we think about?
Schools in places like Florida and Michigan and California have been able to create new policies, and regardless of what they think of these policies, it works, and they still get kids coming to their.
We overturn. Do we worry about public reaction?
Well, no, Your Honor, because that's never been the court's policy when dealing with discriminatory policies. We know that removing segregation through Brown was met with extreme backlash, but that didn't stop.
It was 9-0. History of the court was that they worked real hard to get 9-0 because of. I'm asking, is that a legitimate thing for us to think?
Well, it is.
If it is,
public perception can't outweigh constitutional rights. So if this court finds that, as we believe, courts or schools are discriminating based on race and that's unconstitutional, that trumps what the public will think about it. Now, UNC isn't even following Grutter. Grutter held that university application programs must evaluate the applicant as an individual and avoid separate admissions tracks. But we've seen that different races have much different standards for being accepted.
For example, as I mentioned earlier, we know that the chances of admission for an Asian American applicant who academically outweighs an African American applicant are actually much lower. We also know that the university treats students differently as they look at their applications based on their race. They say that, they're only looking at a certain kid because that kid is African American, or that they're only looking at a kid because he's a biracial.
What to make of that? I mean, if we take seriously this idea that diversity is this hugely important interest, lower the standards as much as they have to lower the standards to attract however many applicants of this race or that race they need to attract.
Well, Your Honor, the issue here is that they're not lowering the standards equally. Asian American students and white students are held to a much higher standard than Hispanic and African American students.
And admissions officers have...
Right. Racial diversity is a compelling interest. Then they need to apply different standards by race if their numbers aren't otherwise working out.
If racial diversity is truly an interest, then they need to lower their standards so they can achieve it without discriminating. That's the way to tailor this policy so they achieve their result of diversity.
And Your Honor, UNC hasn't sufficiently demonstrated that a race-neutral alternative wouldn't achieve the same end.
UNC has even shown that they are not willing to sacrifice legacy donations by removing legacy admissions benefits in order to achieve higher levels of diversity.
And furthermore, UNC isn't following any of the limited guidelines in Grutter. So for these reasons, we ask you to overturn Grutter and rule in favor of the petitioner in this case.
3 seconds left. Thank you very much. Case is submitted. All right.